Be ready. Start. The disposal of natural resources is a facet of the use and distribution of such resources. Article 39b mandates that the ownership and control of natural resources should be so distributed so as to best subserve the common good. Article 37 provides that the provisions of Part 4 shall not be enforceable by any court, but the principles laid down therein are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Therefore, this article, in a sense, is a restriction on distribution built into the Constitution, but the restriction is imposed on the object and not the means. The overreaching and underlying principle governing distribution is furtherance of common good. But for the achievement of that objective, the Constitution uses the generic word distribution. Distribution has broad contours and cannot be limited to meaning only one method, that is, auction. It envisages all such methods available for distribution stroke allocation of natural resources which ultimately subserve the common good. The word distribution used in Article 39b must be broadly construed so that a court may give full and comprehensive effect to the statutory intent contained in Article 39b. A narrow construction of the word distribution might defeat or frustrate the very object which the article seeks to subserve. It is obvious, therefore, that in view of the vast range of transactions contemplated by the word distribution as mentioned in the dictionaries referred to above, it will not be correct to construe the word distribution in a purely literal sense so as to mean only division of a particular kind or to particular persons. The words apportionment, allotment, allocation, classification clearly fall within the broad sweep of the word distribution. So construed, the word distribution as used in Article 39b will include various facets, aspects, methods and terminology of a broad-based concept of distribution. It can thus be seen from the aforequoted paragraphs that the term distribute undoubtedly has wide amplitude and encompasses all manners and methods of distribution, which would include classes, industries, regions, private and public sections, etc. Having regard to the basic nature of Article 39b, a narrower concept of equality under Article 14 than that discussed above may frustrate the broader concept of distribution as conceived in Article 39b. There cannot, therefore, be a cavil that common good and larger public interests have to be regarded as constitutional reality deserving actualization. Learned counsel argued that revenue maximization during the sale or alienation of a natural resource for commercial exploitation is the only way of achieving public good, since the revenue collected can be channelized to welfare policies and controlling the burgeoning deficit. According to the learned counsel, since the best way to maximize revenue is through the route of auction, it becomes a constitutional principle even under Article 39b. However, we are not persuaded to hold so. Auctions may be the best way of maximizing revenue, but revenue maximization may not always be the best way to subserve public good. Common good is the sole guiding factor under Article 39b for distribution of natural resources. It is the touchstone of testing whether any policy subserves the common good, and if it does, irrespective of the means adopted, it is clearly in accordance with the principles enshrined in Article 39b. Two conclusions strike us as quintessential. Part 4, especially Article 39b and c, is a futuristic mandate to the state with a message of transformation of the economic and social order. Firstly, such change calls for collaborative effort from all the legal institutions of the system, the legislature, the judiciary, and the administrative machinery. Secondly, and consequentially, loyalty to the high purpose of the Constitution, namely social and economic justice, in the context of material want and utter inequalities on a massive scale, compels the court to ascribe expensive meaning to the pregnant words used with hopeful foresight, not to circumscribe their connotation into contradiction of the objectives inspiring the provision. To be pharisaistic towards the Constitution through ritualistic construction is to weaken the social spiritual thrust of the founding fathers' dynamic faith. It has been held by this court that the only norm which the Constitution furnishes for distribution of material resources of the community is elastic norm of common good. Thus, common good is a norm in Article 39b whose applicability was considered by this court on the facts of the case. Even in that case, this court did not evolve economic criteria of its own to achieve the goal of common good in Article 39b, which is part of the directive principles. The norm of common good has to be understood and appreciated in a holistic manner. Thank you.